when you're terminated and you're terminated with all your benefits, and one of your major benefits is health insurance, and you have a critically someone within your family, and in my case it was my wife, that needed experimental drugs and they're very expensive, and you're losing an extremely lucrative job with all the benefits. So the first thing is fear is how are you going to continue to take care of your wife. As soon as you find out that you've submitted a complaint or a charge against a supervisor, where you talk directly with the supervisor, from that point on, what begins to take place is isolation. They begin to ostracize you and marginalize you because you now become radioactive. You are considered like a disloyal employee, and friends and associates are fearing for their jobs, and they know that if they were to be seen talking to you, that you might be sharing information about your complaint with other witnesses. My greatest fear, I think, is just the common fear of the loss of the wages and the loss of the benefits. And because in this sense, my wife living depends on these experimental drugs.
Buried in the fine print of credit card billing inserts, cellular phone service disclosures, employee handbooks, health insurance plans, and franchise agreements, mandatory or forced arbitration clauses eliminate Americans' access to the courts, forcing them instead into a costly, private legal system that favors corporations. Employers and businesses use these hidden clauses to protect themselves against lawsuits. They like to say that people have a choice to use arbitration or to go to court, but they really don't. If someone refuses to sign a contract with forced arbitration but still shows up for work or uses a product or service, they lose even the option of going to court. Even if they never read the clause, which is usually buried in the fine print, they are forced to use an expensive private legal system of arbitration or private justice instead of getting their day in court in a fair jury trial. Public Citizen, a consumer advocacy group, has compiled a forced arbitration corporate rogues gallery, a list of companies that includes forced arbitration in their consumer and employment contracts. These corporations are rigging the justice system against consumers and employees. A study was done that shows 95% of decisions are against consumers and employees. So it's a sham. It's grossly unfair and unconstitutional. Americans should never have to give up their basic constitutional rights, such as a jury trial by their peers, an impartial and qualified judge, to discover evidence for their case, to appeal or bring a class action lawsuit, just to do the everyday things in their lives. In this insider exclusive investigative network TV special, our news team goes behind the headlines in Mandatory Arbitration, Corporate America's Get Out of Jail Free Card, Bud Taylor's story, to examine how Brian Sanford, founder of the Sanford Law Firm, successfully won an arbitration award for his client Bud Taylor in a case involving retaliation for opposing discrimination. In Bud Taylor's case, Brian Sanford had to prove that but for Bud's opposition to discrimination, he would have not been terminated from his job. The arbitration process should be optional and not a mandatory waiver of the right to a jury trial secured by the 7th Amendment to the Constitution. This is a serious and widespread problem in the United States. Brian answers very important questions we've all got regarding mandatory arbitration, such as, what is arbitration, and especially mandatory binding arbitration? Where is mandatory arbitration commonly used? What's wrong with arbitration? How mandatory arbitration means giving up the most fundamental legal protection, the right to equal justice under the law. Why do so many consumer, employment, and civil rights groups oppose forced arbitration? What can we do about the problem? What if you need legal help against a company using a mandatory arbitration clause? There are reasons why companies demand arbitration which have nothing to do with justice. Employees have little choice but to forego their rights in court and to participate in the process. Here's how consumers and employees are hurt by the mandatory arbitration agreements, usually buried in the fine print. When corporations impose arbitration in non-negotiable contracts using their bargaining power to take away people's legal rights, it becomes an abusive weapon. Corporations have created one-sided forced arbitrations that burden consumers and employees and deprive them of equal justice under the law. Arbitration is a private justice system without an impartial judge, jury, or meaningful appeal. There is no public review of decisions to ensure the arbitrator got it right. Federal law does not require that arbitrators have legal training or even follow the law. Arbitrators' decisions must be upheld, even if they disregard the law. Americans need a system that is transparent and accountable to the public for a change. Mandatory arbitration means giving up the most fundamental legal protection, the right to equal justice under the law. Laws that protect employees against discrimination based on age, sex, religion, race, disability, and unequal pay for equal work, such as the Civil Rights Act and the Equal Pay Act. But these laws are meaningless if unenforceable in court. It's time to close the arbitration loophole that gives employers the right to ignore civil rights and weakens civil justice safeguards. When Congress enacted the Federal Arbitration Act in 1925, its goal was to allow an alternative forum for commercial parties on equal footing to resolve their disputes. The use of forced arbitration to settle employment claims has risen rapidly since the early 1990s. In 1991, Congress made jury trials and money damages available under Title VII. In 1992, Congress passed the Americans with Disability Act, but these expansions of workers' protections were undermined in 1991 when the Supreme Court permitted an employer to force its employees to resolve disputes in arbitration. An estimated 15% to 25% of American employers have adopted forced arbitration policies. This means that more than 30 million employees, 1 out of every 4 non-union workers, have given up their right to go to court. Instead, their contracts designate an arbitration firm selected by the employer to resolve any disputes. Forced arbitration clauses effectively allow employers to shield themselves from the purview of employment laws. This should alarm every worker in the United States. Big business and corporate money, along with a corporate-friendly Supreme Court, have been enough in the past to defeat efforts to bring fairness back to the arena of routine consumer and employees' rights. In 2 recent cases, AT&T Mobility versus Concepcion and American Express Company versus Italian Colors Restaurant, the Supreme Court held that mandatory arbitration clauses should be enforced against plaintiffs, even though doing so would make pursuing a legal claim so economically irrational that in all likelihood, no cases would ever get brought. The Concepcion and the Italian Colors cases represent a concerted effort on the part of our nation's highest court to enforce consumer contracts more strictly to the letter. In the 2011 AT&T Mobility versus Concepcion, the court ruled that corporations can now use this fine print to deny people the right to band together for a class action lawsuit. In practice, this means that if a company decides to illegally charge an extra $10 to its 10 million customers, there is virtually no way for consumers to hold the company accountable for this theft of $100 million. It's basically a corporate get-out-of-jail-free card. As the law exists now, you do not have the right to file a lawsuit for many consumer and employee and civil rights complaints. The good news is that this problem can be fixed with the Arbitration Fairness Act. The proposed Arbitration Fairness Act legislation, supported by Senators Franken, Blumenthal, Sanders, Boxer, and others, would make arbitration agreements unenforceable in the employment or consumer context unless the agreement is made after the underlying dispute arises. The Arbitration Fairness Act would eliminate forced arbitration clauses and allow consumers and employees to choose how to resolve disputes after it arises, whether in court or arbitration, individually or as a member of a class. We can all stop the corporate attack on people's rights by contacting your members of Congress to support the Arbitration Fairness Act. Brian Sanford and his firm have earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Dallas, in Texas, and in the nation, fighting for equal justice of all Americans. His goal is not only to get justice for his clients, but to make sure that all individuals receive equal protection and justice under the law as guaranteed by the United States Constitution. Americans deserve judges who believe that the Constitution provides for fair and equal justice for everyone in America, not just for the wealthy and the powerful. This is the Insider Exclusive, live from Dallas, Texas. It is my great pleasure to introduce Brian Sanford to the show. Welcome to the show, Brian.
Thank you, Steve.
Tell our audience a little bit about what type of law your firm practices.
We practice primarily employment law, mainly representing employees and protecting their rights in wrongful termination, discrimination, retaliation, pay.
What are some of the more common problems that you see of people coming into your office?
The common problems that we see actually mainly are retaliation after standing up to prevent a violation of the law.
Yeah.
So whether it's a whistleblower or trying to stop a sexual harassment or discrimination, there's an underlying violation,
right,
which is illegal itself. But what we find is when they try to stand up against that, that's when the real harm comes and the termination comes.
Today, we're doing a very interesting show on one of your cases, Bud Taylor. And it's a case involving the issue of mandatory arbitration, which we find to be, a curse, if you will, against anybody who signs a contract, whether it's an employment contract, consumer contract. And the law of the land today is businesses are allowed to do this. Tell our audience a little bit about your client. First of all, Bud Taylor. Who is he?
Bud is an older gentleman, very smart, very driven, very kind, very faithful and loyal to any employer he works for, and always worked for large companies and has a military background, and is kind of a perfectionist. But he's also one of these guys that he's going to stand up for what's right, no matter the cost.
Before he came to you, he was working for a company, correct?
Yes.
And there was a disagreement that came up, which forced him into mandatory arbitration, correct?
Yes.
Because that was part of his contract.
Yes.
And what happened? He handled this himself initially.
Yes, he handled it himself. They had a step process where you could go to your supervisor and then manager, HR. Ultimately, if you couldn't receive any relief, you were not allowed to file a lawsuit. You were not allowed to go in an open court of law with a neutral judge and a jury. You had to go in front of a private judge through arbitration.
And this is all signed in his contract?
It's all signed in a contract.
Yeah.
He'd actually had experience with a prior employer, the same problem, and had represented himself through arbitration unsuccessfully.
Yeah. Now, why was he in arbitration to begin with? What had they accused him of doing?
Well, they accused him of not performing. But it all came after he complained about being treated differently because of his age.
Really?
So once he complained, then he received a reign of terror, and then he stood up against the retaliation. Well, the retaliation only became more severe, and he just stood up ever more until finally they marched him out the door, even after he filed for the arbitration.
His efforts by himself to get redress, if you will, for the wrongs that have been done to him, how did they end up by himself?
Disaster. His two prior arbitrations were not successful.
Yeah.
When he finally came to me,
And he represented himself.
He represented
correct?
himself.
Yeah.
And he came to me, and we represented him, and he
In a
was
third arbitration.
in a third arbitration against it's another employer.
Yeah.
But he was successful in this one. But that's a rare event.
Yeah.
I don't know if you know, but in Texas, you can simply be an employee. The employer puts in the employment policy,
Yeah.
an arbitration provision, and if you don't quit the next day,
Yeah.
then you've waived your constitutional right to a jury trial.
Right.
It's really fundamentally taking the right, the constitutional right, to a jury trial away from individuals.
And the purpose of a jury trial is to have your grievances aired to a jury of your peers so they can see what's fair. Basically, in mandatory arbitration, this is why we're doing this show, the deck's stacked against the employee. Oftentimes they have to sign, when they sign their employment contract, it is already embedded in there. If you don't want to sign it, you don't work there, correct? This isn't fair, is it?
Well, how is it fair to give up your right to an open trial in open court with a neutral judge in front of a jury when there hasn't even been a claim?
Now, this has been going on for years. There's legislation that's been proposed for a number of years. You and I were talking before the show. I thought it was 2009, maybe earlier, called what?
The Arbitration Fairness Act.
Which would allow what?
Basically, in any situation where it would hold unenforceable any agreement to arbitrate unless it was made after the dispute arose in an employment or consumer context.
Yeah. In other words, if there is a problem that arises, then you're presented with two choices. Go to court or arbitrate.
Sure, after the dispute arises, there's equal bargaining power. If the person says, I want to arbitrate, fine, but not before when there's no bargaining power.
Right. Today we're fortunate to have Bud with us, so let's bring him on right now. Hi, Bud. How are you?
I'm doing well.
I'm glad you're here today.
Thank you.
This show interests us tremendously because every employee today, or many consumers today, when they sign an agreement with that company to buy a product, buried in that agreement are the words mandatory arbitration. And we're trying to change that. We're trying to alert the public as to what they're signing. Now, you have been a successful businessman. You have worked for many companies over the years, and you have signed a number of these employment contracts where mandatory arbitration was buried in there, right?
Absolutely.
When you signed the contract, did you give it a second thought about mandatory arbitration?
I already knew what it was about, and so I signed. I knew it was take it or leave it.
Now, you've had experiences before where you have gone through the arbitration process and lost, correct?
That's correct.
Yeah, even though you considered your position right.
Absolutely.
Yeah. Why did you lose? You tell us in plain, simple English.
I felt that if I researched it and I worked hard and worked smart as a pro se, that I might get a fair hearing before an arbitrator, and I found out differently.
Yeah, in other words, you felt if you go there and just throw yourself up there and say, here I am, a good guy, and I'm telling the truth, that they'll see that, right?
No, actually I knew that it was very litigious and very rigorous, and my preparation was the same.
You were terminated, is that correct?
Yes.
Okay, and how did that, a lot of people think, well, that's a word, you got terminated, but now you're not getting income, correct?
Correct, that is correct.
How did that affect you and your family?
It affected my wife. My wife is an advanced Crohn's patient and critical Crohn's patient, and like the drug she's going to begin to take is like $85,000 a month in bill charges. So the very, very expensive and very experimental drugs. And so I did everything I could to fight through and keep my salary coming in as long as possible so that I would still have the employee benefits, the drug benefits, and the money to be able to sustain ourselves through these times.
And the insurance coverage too, right?
You lose everything.
Yeah. Hey, Brian, during this process, this multi-step process here, fair treatment, whatever it's called, Is an employee allowed to be represented by a lawyer?
They are once it reaches to formal arbitration. Before that,
No, I'm talking about so you don't give away all this information. No.
Not directly behind the
fine.
scenes, but not directly.
All right, very good. Well, congratulations on your award. Not too many people get them, and congratulations on that. And I want to thank you very much for being on the show and sharing this information. Thank you.
You're very welcome. I appreciate it.
How do you pick your clients in your cases? I mean, a lot of people call you up, come into your office and say they've got a legitimate claim against their employer. How do you select them? What do you analyze?
Two things. First, we have to look to see if there's a law that protects them.
Yeah.
We're willing to expand the law, but there has to be something that we can build upon. And unfortunately, in most situations, there's not a law that protects many of the wrongs that occurs. So we look to the law first. Second, we look at that person and we say, is this a good person? Were they a good employee? Was there really a wrong? And can we win with the truth at the end of the day?
I want to thank you very much for being on our show today, because without lawyers like yourself, because you do take these cases on contingency, and for our audience that doesn't know what that means is you don't get paid if you don't win the case. So you have to be careful on the cases you're taking.
We rise and fall with our clients.
Okay, and I want to thank you for doing that and being successful at what you do. Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.